Good morning, ladies and gentlemen, and a very warm welcome from the beautiful Bangunan Sulaiman, the home of the Asian International Arbitration Center in Kuala Lumpur, Malaysia. I hope you're all keeping safe and well as we finally start to see the light at the end of the tunnel, with vaccination programs gaining momentum across the globe. Japanese scholar Okakura Kakuzo once said that the art of life is a constant readjustment to our surroundings. The past 18 months have certainly required all of us to make constant readjustments to our lives as we have grappled to accept, navigate, and embrace the new normal. However, it is undeniable that these new experiences also presented many businesses and organizations with the opportunity to be introspective, reconsider age old practices, and explore innovative solutions to deliver a more modernized and sophisticated service offering for the benefit of their clients, users, and stakeholders. Now, this statement certainly holds true to the AIAC. On 1st August 2021, the AIAC proudly published the AIAC Arbitration Rules 2021, or the 2021 Rules. The 2021 rules showcase a significant departure from its predecessor, the AIAC Arbitration Rules 2018, which was last amended in 2018 to signify the center's name change from the Kuala Lumpur Regional Centre for Arbitration, or KLRCA, as was more fondly known, to the AIAC. The 2021 rules not only provide greater clarity on the operation of existing provisions in the AIAC's suite of arbitration rules, but they also incorporate several new provisions which ensure that the procedural rules adopted by the AIAC reflect international best practices and standards. In this regard, it is my sincere pleasure to present to you an overview of the drafting of the newly launched 2021 rules alongside showcasing the key features of the 2021 rules. I hope that this comprehensive overview will enable all of the AIAC's users and stakeholders, as well as the wider arbitration community, to better understand the mechanics and benefits of the AIAC's latest innovative product offering. The drafting of the 2021 rules was a process that commenced in mid 2019. The ambition for revising the rules was to ensure that the AIAC continues to provide a holistic dispute resolution mechanism that recognizes the changing demands of the evolving ADR market with more sophisticated provisions that are catered to sectoral and regional demands. The announcement in May 2019 that the AIAC arbitration rules were selected for the 2022 VISMUTs, namely the 29th Willem C. Vis International Commercial Arbitration Moot in Vienna, Austria, and the 19th Willem C. Vis East International Commercial Arbitration Moot in Hong Kong, was one of the many catalysts which spearheaded the AIAC's rules revision efforts. This selection was truly a shining moment for the AIAC because since 2017, the AIAC has been organizing pre-moots to the VISMUTs, where the AIAC's most recent pre-moot held in March 2021 was one of the largest in the world. More importantly, the selection of the AIAC arbitration rules for the 2022 VISMUTs has presented the AIAC with the unique opportunity to increase awareness about Malaysia as a modern arbitration jurisdiction, both to the global arbitration community and to the next generation of arbitration practitioners. In this spirit, the AIAC decided that the time was ripe to consider revising its 2018 rules to ensure that the product used in the 2022 VISMUTs would reflect Malaysia's positioning as an emerging arbitration hub. The process of revising the AIAC arbitration rules commenced with extensive research being undertaken by the AIAC's legal services team to compare the 2018 rules with the prevailing best practices in international arbitration. For this purpose, the AIAC legal services team reviewed the arbitral rules of nearly 20 arbitral institutions across the globe while also collating key judicial updates worldwide that had a bearing on procedural aspects of the arbitration process. In March 2021, the AIAC established an external advisory committee known as the Rules Revision Committee, comprised of esteemed domestic and international arbitration practitioners to assist in revising and providing feedback on the AIAC's proposed amendments to the 2018 rules. A key feedback from the first consultation with the Rules Revision Committee was that the AIAC should consider merging Parts 1 and 2 of the 2018 rules. Specifically, Part 1 of the 2018 rules contains provisions that are unique to the AIAC's case administration. Part 2 reproduces the UNCITRAL arbitration rules as revised in 2013, such that the UNCITRAL rules are deemed incorporated into the 2018 rules. Being cognizant that a harmonized set of arbitration rules would minimize any inconsistency and result in a highly streamlined and user-friendly set of procedural rules, the AIAC took this feedback on board as part of its second round of revisions to its arbitration rules. Additional changes that were made following the first consultation with the Rules Revision Committee included 1. Clarifying the process for the appointment of the arbitral tribunal in multi-party proceedings. 2. Clarifying the grounds upon which an arbitrator may be challenged or replaced. 3. Strengthening the provisions relating to the joinder and consolidation of arbitrations, including the ability to register multi-contract arbitrations. 4. Incorporating provisions on the conduct of arbitral proceedings, including explicitly permitting the conduct of virtual hearings. 5. Incorporating an expedited arbitration process within the main set of arbitration rules. 6. Clarifying the conduct of an emergency arbitration proceedings. 7. Clarifying the method for collection of deposits. 8. Streamlining the process of declaring the closure of proceedings and the drafting and technical review of arbitral awards. And 9. Strengthening the provisions relating to the confidentiality of proceedings and non-liability. Thereafter, the AIAC's legal services team devoted 8 weeks of solid efforts into finalizing the second draft of the 2021 rules to ensure that the comprehensive comments made by the Rules Revision Committee could be appropriately captured and reflected in our revised rules. Given the extensive nature of the amendments made, the AIAC was required to consult with the Rules Revision Committee once again on its second draft of the 2021 rules, wherein further pertinent feedback was provided. Once this feedback had been analyzed and appropriately reflected in our third draft of the 2021 rules, the AIAC commenced a 15-day public consultation process on its draft 2021 rules. The public consultation witnessed a number of engaging and insightful comments from key players in the regional arbitration space that the AIAC legal services teams once again took on board and effected further amendments to what has now become the official 2021 rules. On that note, and on behalf of the AIAC, I would like to take this opportunity to personally thank the members of our Rules Revision Committee for their dedication to and support of the drafting of the AIAC Arbitration Rules 2021, namely Anna Grishenkova, Professor Chin Ling Lim, Dr. Karina Baltag, Dr. Nitin Nadkarni, Ms. Erin Miller-Rankin, Mr. Fu Junliang, Dr. Hassan Arab, Professor Jungi Kim, Professor Maxi Scherer, Mr. Nahindra Navaratnam, Mr. Nicholas Lingard, Mr. Peter Godwin, Mr. Rajendra Navaratnam, Ms. Sitpa Silvaratnam, Mr. Sunway, Ms. Tan Sui Im, and last but not certainly least, Mr. Vyapak Desai. Having provided a comprehensive overview of the drafting of the 2021 rules, I will now turn to highlighting the key features of the 2021 rules. The first point I would like to highlight is that as part of the introduction to the 2021 rules, we have provided an updated model arbitration clause that parties can consider, including as part of their contractual arrangement. We have also provided a model submission agreement to assist parties with referring any current or prospective dispute to arbitration where either an arbitration agreement presently does not exist or where one does exist but such agreement does not make reference to the AIAC arbitration rules. A noticeable change in the text of the model arbitration clause and the model submission agreement is the broadened scope of the disputes that can be referred to arbitration. Specifically, the language now encompasses any dispute, controversy, difference, or claim arising out of or in relation to the contract, including contractual claims relating to the performance, breach, termination, or invalidity of the contract, as well as any non contractual claims. We have also provided a list of recommended inclusions to the Model Arbitration Clause and the Model Submission Agreement, such as a provision relating to the seat of the arbitration, the number of arbitrators, the language of the proceedings, and the law governing the arbitration clause or submission agreement. In the spirit of encouraging expedited arbitrations, we have also included an optional provision that can be added to either the Model Arbitration Clause or the Model Submission Agreement for conducting arbitrations in accordance with the fast-track procedure in Rule 8 of the 2021 rules. Moving on to the preliminary provisions in the 2021 rules. Rule 1 is a general provision that casts a wider net on the sort of arbitrations that would be classified as arbitrations administered by the AIAC. Specifically, the rules now provide that if the parties have agreed to refer their dispute to the AIAC or for arbitration in accordance with the AIAC Arbitration Rules, then the arbitration shall be conducted and administered by the AIAC. Now, we considered this change necessary given that there have been many instances where the parties had agreed that the arbitration shall be referred to the AIAC, but the arbitration clause made no specific reference to the AIAC arbitration rules. In the majority of these instances, the parties had confirmed to us their intention for the dispute to be administered by the AIAC, although there was no specific reference to the AIAC arbitration rules in these provisions. To minimize any further confusion in this regard, we considered such an amendment to be necessary. An interesting feature of the Rule 1 is Rule 1.4, which permits the use of third-party funding in arbitrations administered by the AIAC, provided that a relevant law does not provide otherwise. We at the AIAC are cognizant that third-party funding is gaining momentum globally and is regularly used in arbitration proceedings in other Asia-Pacific seated arbitrations. Third-party funding is presently not recognized in Malaysia due to the continued recognition of the doctrine of champity and maintenance by Malaysian courts. Nonetheless, we do recognize that for arbitrations seated outside of Malaysia that are to be administered by the AIAC, flexibility needs to be accorded to the extent permissible for the parties to find a suitable mechanism to finance their proceedings. As such, we hope that this inclusion in the 2021 rules will see an increase in arbitrations subject to third-party funding being referred to the AIAC. Rule 2 of the 2021 rules contains a revamped guide and definitions provision. Notable inclusions are the distinctions between awards, final awards, and consent awards for the purposes of the technical review process, an amendment to the definition of international arbitration to include arbitrations that are seated outside of Malaysia where neither party has its place of business at the seat, and a wide definition of the word virtually to keep in line with the global trend of having institutional rules that explicitly permit the conduct of virtual proceedings. Rule 3 of the 2021 rules is a new communications and calculation of time limits provision that adopts and expands on Article 2 of UNCITRAL Arbitration Rules as revised in 2013. The specific additions relate to clarifications on how the service or the delivery of documents is deemed to be effected where there are multiple parties or multiple addresses or modes of service on the same party. There is also a new provision that recognizes the validity of documents executed by the director of the AIAC or the AIAC electronically, given that such execution has been prevalent over the course of the past 18 months. The new representation provision in Rule 4 of the 2021 rules mimics Section 3A of the Malaysian Arbitration Act 2005, which clarifies that a party may choose to be represented by any representative in an arbitral proceeding as opposed to only being represented by a lawyer. For transparency purposes, we have also included a provision requiring a party to notify the AIAC, the arbitral tribunal, and the other party of any changes in representation, given that we have encountered a handful of instances where such communications were not made in an arbitral proceeding, which proved to be problematic. Rules 5 and 6 of the 2021 rules now prescribe the contents of the notice of arbitration and the response to the notice of arbitration and are modeled on Articles 3 and 4 of the Arbitral Arbitration Rules as revised in 2013, save for some linguistic amendments and some additional inclusions. Specifically, Rule 5.3 now enables parties to file a single notice of arbitration and pay a single registration fee where claims arise out of multiple contracts. Now, this is on the proviso that a consolidation request is also submitted to the AIAC at the time of registration to enable the director to consider whether or not the multi-contract arbitrations should be consolidated at the outset as a single dispute. We believe that the inclusion of such a provision would be welcomed by many parties, particularly those in the construction industry, where it is fairly common to have multiple contracts between the same parties on a particular project, which in turn will hopefully make the arbitration process more streamlined. With respect to Rule 6, Rule 6.1c now makes it a requirement for a party serving a response to a notice of arbitration to include a brief statement describing the nature of any counterclaim or set-off it intends to raise in the proceedings. Under the Arbitral Arbitration Rules, as revised in 2013, such a statement was considered optional. Our decision to make such a provision mandatory was twofold. Firstly, knowing the nature of any counterclaims or set-offs would make for a more efficient arbitration, as the parties would have a legitimate expectation of the nature of claims and arguments that would be raised during the course of the proceedings, which in turn would assist in their case strategies. Secondly, having a quantified counterclaim at the outset would also enable the AIAC to collect a more reasonable deposit to cover the costs of the arbitration, as there are many instances where once the statement of defense and counterclaim has been submitted, the cost of the arbitration skyrockets and places a large financial constraint on the parties. Our new registration provision in Rule 7 of the 2021 rules has been amended to make it more apparent what needs to be actioned to register and commence a matter with the AIAC. Specific mention should be given to the inclusion of Rule 7.2g, which requests the party submitting the registration request to provide a statement on whether any preconditions to arbitration have been satisfied or waived by the parties. This was not explicitly provided for in the 2018 rules, although as a matter of practice, the AIAC's legal services team would verify the same with the parties prior to confirming the commencement of an arbitral proceeding. Another notable departure from the 2018 rules is that pursuant to Rule 7.5 of the 2021 rules, an arbitration is deemed to have commenced once the notice of arbitration has been delivered to the respondent, while the registration of the arbitration is deemed to take effect once the AIAC receives a complete registration request pursuant to Rule 7.2. Now, we considered such an amendment necessary to bring our registration and commencement provisions in line with Malaysia's legal framework, where the default position is that an arbitration commences once the respondent is in receipt of the notice of arbitration. This is also the act that stops the limitation period for a party to bring an action in arbitration against another in Malaysia. One of the primary highlights of the 2021 rules is the incorporation of a self-contained fast-track procedure within the 2021 rules. Now, as many of you would know, the AIAC maintains a standalone product for the conduct of expedited arbitrations known as the AIAC Fast-Track Arbitration Rules 2018. Now, our original plan was to amend the 2018 Fast-Track Rules once the 21 rules had been published. However, we realized that given that many of the provisions in the normal arbitration rules and the fast-track arbitration rules were analogous, save for the specification of thresholds for the applicability of a fast-track arbitration and the prescription of time limits in the same, it would be more efficient and user-friendly to embed a fast-track procedure within the 2021 rules itself. As a result, the fast-track procedure in Rule 8 effectively replaces the AIAC Fast Track Arbitration Rules 2018 for arbitrations commenced on or after 1st August 2021, unless otherwise agreed to by the parties. The fast track procedure also contains an achievable time frame of 180 days within which the final award shall be rendered by the arbitral tribunal from the delivery of the first procedural order by the arbitral tribunal. We have taken the opportunity to revisit a number of the time limit provisions enshrined in the 2018 fast track rules to ensure for a smoother arbitration. Uniquely, Rule 8.10 of the 2021 rules also permits an arbitral tribunal to opt out of the fast track procedure if it is impractical for the arbitral proceeding to be conducted in accordance with the prescribed time limits. With this mechanism, we hope to continue to provide our administrative support services to such proceedings to ensure a more efficient and hassle-free arbitration. Rule 9 of the 2021 rules is our new appointment provision, which largely reiterates Rule 4 of the 2018 rules. Some noticeable changes are the inclusion of a specific appointment process where the parties have opted for an even-numbered arbitral tribunal, as well as a new provision on multi-party appointments, which aims to overcome the issues relating to the equal treatment of parties raised in the Siemens-Dutco decision of the French Court of Cassation. With respect to multi-party appointments specifically, the new Rule 9.7 prescribes a separate procedure for the appointment of both even and odd-numbered arbitral tribunals, whereby the multiple claimants or the respondents are to act collectively in nominating their share of the required number of arbitrators, failing which, the director will constitute the entire arbitral tribunal and will exclude or release any nominated or appointed arbitrators from consideration unless otherwise agreed to by the parties. In the spirit of enhancing transparency, Rule 9.8 of the 2021 rules now also prescribes that the default mode of appointing the arbitral tribunal by the director of the AIAC would be by list procedure, unless otherwise agreed to by the parties or determined by the director. We are positive that this added layer of transparency in the appointment process would make parties and the broader arbitration community more confident in the manner by which the director exercises his power of appointment, which in turn would enhance the utility of arbitration as a consensual dispute resolution mechanism. The 2021 rules now contain a new provision in Rule 10 on the impartiality, independence, and availability of the arbitral tribunal to reinforce the matters prospective arbitrators should have in mind at the time they are approached in connection with an appointment in an arbitration matter. Importantly, greater emphasis has been placed on the importance of the arbitral tribunal to remain impartial and independent at all times and to ensure that proper disclosures of any perceived conflicts are made throughout the course of the arbitral proceedings. The language of the challenge provision in Rule 11 has also been modified to factor in situations where a party is aware of an existing circumstance at the time of the arbitrator's appointment, and that circumstance does not give rise to any apparent conflict at that point in time, although a change in circumstances during the course of the arbitral proceedings later gives rise to justifiable doubts. We anticipate that by availing such a provision, the parties would be able to address any allegations of bias at an early stage of the arbitral proceedings, rather waiting for the release of the final award to refuse the recognition and enforcement of the final award. The new challenge provision also clarifies how the director will remunerate any challenged arbitrator who is removed from the proceedings, as well as how that arbitrator's replacement will be appointed to carry on with the proceedings. Rule 12 of the 2021 rules is a new provision that specifies the circumstances in which the director may replace a member of the arbitral tribunal. Interestingly, Rule 12.2 enables the director to replace an arbitrator on his own initiative and after consulting the parties and the arbitral tribunal if the prescribed circumstances exist. Now, it goes without saying that such a power would only be enlivened by the director in the most exceptional circumstances, including situations where an arbitrator is incapacitated due to a prolonged injury or illness. To enhance the operation of the replacement provision, we have also clarified matters relating to the remuneration of any arbitrator that is replaced, as well as drawing the reconstituted arbitral tribunal's attention to matters relating to the subsequent conduct of the proceedings. This brings me to the next rule, that is Rule 13, which concerns the conduct of proceedings and the powers of the arbitral tribunal. The 2018 rules did not contain a specific provision relating to the conduct of proceedings, although they did contain a provision relating to the broad powers of the arbitral tribunal. Over the course of time, we have noted many instances where we have been approached by members of the arbitral tribunal for guidance on how best to conduct their proceedings and the nature of the powers that are exercisable by them. In this regard, we have set out some general matters to assist in the preliminary conduct of the arbitral proceedings, which we hope would aid arbitral tribunals, especially tribunals comprising of first-time or young arbitrators, to have more confidence in controlling the flow of the proceedings. To further assist the arbitral tribunal, the AIAC also offers a formal tribunal secretary service where the director can assign an AIAC case counsel who is not the case counsel in charge of the proceeding to provide secretarial support to the arbitral tribunal. This service is now reflected through the inclusion of Rule 13.4 in the 2021 rules, with a separate guide and protocol to be released in the coming weeks. An additional power which we would like to highlight is the express power of the arbitral tribunal to make inquiries on the existence of third-party funding arrangements, including the third-party funder's economic interest in the proceedings. Once again, we hope that the inclusion of such a provision would assist in making the 2021 rules more appealing in disputes where third-party funding is likely to be employed. Moving on to the provisions that relate to the seat and language of arbitrations. Rule 14 exemplifies that the parties and the arbitral tribunal may choose to have meetings, conferences, deliberations, or hearings take place either in place or virtually without affecting the choice of the seat of arbitration. We are hopeful that such a clarification would do its part in promoting the use of virtual solutions for the efficient conduct of arbitral proceedings, while also minimizing any concerns relating to enforceability attributable to the same. Rule 15, which relates to the language of the arbitral proceedings, now has a new inclusion which expressly empowers the arbitral tribunal to order the translation of a document or other communication that has been submitted in language other than the language of the arbitral proceedings. Rule 16 of the 2021 rules relate to the power of the arbitral tribunal to award interim measures. This rule is predominantly a reproduction of Article 26 of the UNCITRAL Arbitration Rules as revised in 2013 and also reflects Sections 19 to 19J of the Arbitration Act 2005. Tied to Rule 16 are Rules 17 and 18, which relate to the appointment of an emergency arbitrator and the conduct of emergency arbitration proceedings. These provisions are not new to the AIAC Arbitration Rules. Rather, they have been moved from Schedule 3 of the 2018 rules into the main text of the 2021 rules. We have also made some linguistic changes to provide greater clarity to these provisions, given that some concerns were raised to us regarding the ambiguity of the earlier provisions. Rule 17.1 specifically provides that an emergency arbitrator request can be submitted where urgent interim measures are sought prior to the constitution of the arbitral tribunal. The emergency arbitrator request will be considered by the director, and if approved, an emergency arbitrator will be appointed by the director within 2 days of receiving the request. Thereafter, the emergency arbitrator is required to issue a first procedural order within 3 days of their appointment, following which an emergency award shall be delivered to the AIAC no later than 15 days thereafter. As such, the entire emergency arbitration process can be completed within a 21-day period. We have also included provisions relating to the conduct of emergency arbitration proceedings. such as permitting the conduct of proceedings in absentia, where a party fails to participate in the emergency arbitration, clarifying that the proceedings can be conducted physically, virtually, or on a documents-only basis. And we have also clarified that the emergency arbitrator is empowered to make any order or award that the arbitral tribunal itself may make, although the arbitral tribunal has been given the ultimate power to consider whether the emergency award shall be retained or vacated. Another new inclusion in the interest of creating a more efficient arbitration process is the new summary determination procedure in Rule 19 of the 2021 rules. The summary determination procedure is similar to the early dismissal procedures that are found in many institutional rules, such as those of the LCIA, SIAC, and HKIAC. The purpose of this provision is to ensure that any claims, counterclaims, or defenses that are manifestly without merit, including legal or factual merit, can be dismissed by the arbitral tribunal at an early stage of the proceedings. This places an onus on the parties to ensure that they are able to properly articulate their claims in the early pleadings in the proceeding. A summary determination request can be filed by any party within 30 days of the filing of the statement of defense and counterclaim, and the request itself will be determined by the arbitral tribunal within 45 days of its receipt of the final submission in relation to the summary determination request. We anticipate that the inclusion of this provision will provide time and cost efficiencies to parties and the arbitral tribunal, which in turn will strengthen confidence in arbitration as an effective dispute resolution mechanism. The joinder and consolidation provisions in Rule 21 and 22 of the 2021 rules predominantly reflect the equivalent provisions in the 2018 rules, save for some changes to the applicable tests and a new provision in the consolidation provision relating to multi-contract disputes. Specifically, Rule 21.1 permits the submission of a joinder request on the new ground that the participation of the additional party to be joined is necessary for the efficient resolution of the dispute, and that such participation directly affects the outcome of the arbitral proceedings. We considered such an inclusion necessary as we are aware that there are at times residual grounds to those enshrined in Rule 21.1a and b that would warrant the joinder of a third party to a proceeding. An example would be where an entity that is not a party to the arbitration agreement nonetheless has a controlling interest in one of the parties to the arbitration that would warrant its participation in the proceedings. We have also clarified that the test for approving or rejecting a joinder request shall be one that considers all relevant circumstances as opposed to any relevant circumstance to bring our joinder provision in line with similar tests in other institutional rules. With respect to consolidation provision in Rule 22, we have now included Rules 22.4 and 22.6 to permit the consolidation of multi-contract disputes in a single notice of arbitration. If the director dismisses such a multi-contract consolidation request, the claimant would be required to serve separate notices of arbitration with respect to each dispute and file separate registration requests with the AIAC. Also worth highlighting are our revised provisions in Rules 32 to 39 of the 2021 rules relating to the closure of proceedings, the form and contents of awards, the technical review process, and the issuance of additional awards. This provision essentially expands on Rule 12 of the 2018 rules, while also incorporating Articles 33 to 34 and 36 to 39 of the Arbitral Arbitration Rules as revised in 2013. Specifically, Rule 32 clarifies when the arbitral tribunal is required to declare the closure of proceedings and how such shall be declared in the context of bifurcated proceedings or in instances where the arbitral tribunal intends to issue multiple awards in a multi-party proceeding. Rule 32.5 also empowers the arbitral tribunal in exceptional circumstances to consider reopening a closed proceeding prior to the delivery of the final award, provided that the director has been consulted on the same. Rule 33, which relates to decision-making and the form of awards, clarifies how a majority decision may be arrived at where an arbitrator is in dissent. It also explicitly provides for the arbitral award to be signed either physically or electronically in light of the increasing trend for electronic signatures attributable to the pandemic. Rule 34 provides a detailed explanation of the technical review process that will be undertaken by the Director of the AIAC on the draft final award. Importantly, it is clarified that the technical review is not a merits review process. However, its process is to draw the arbitral tribunal's attention to any perceived irregularities in the draft form of the draft final award, including matters relating to the procedural history, general content issues, and any clerical, typographical, or computational errors. Since the introduction of the technical review process in 2017 through the AIAC Arbitration Rules 2017, the Director of the AIAC have undertaken a technical review of more than 50 arbitral awards, where many of the arbitral tribunals whose awards were subject to technical review have acknowledged the diligence of the AIAC's legal services team in drawing the arbitral tribunal's attention to a range of procedural irregularities. Rule 36 is also a new provision that reflects and expands on Article 36 of the Arbitral Arbitration Rules as revised in 2013 by setting out the manner in which the arbitral tribunal may deal with the settlement or termination of an arbitral proceeding. Of note is Rule 36.1, which requires the arbitral tribunal to turn its mind to whether the dispute is arbitrable and the settlement is genuine and within its jurisdiction. The purpose of this inclusion is to deter the use of arbitration proceedings as a vehicle for money laundering, thus enhancing the legitimacy of the arbitration process. Rule 39 is also noteworthy given that it expands on the additional award provision as contained in Article 39 of the Arbitral Arbitration Rules as revised in 2013. We considered it prudent to provide a more detailed provision given that the language of Article 39 was rather ambiguous. Rule 39 clearly explains the instances where an arbitral tribunal may consider issuing an additional award. Specifically, the arbitral tribunal may do so on its own initiative if it is considered appropriate following an interpretation of an award pursuant to Rule 38 or a correction to an award pursuant to Rule 38. Additionally, a request for an additional award can also be submitted by a party, provided that such request is made within 30 days after the receipt for an order for the termination of the proceedings or the receipt of the final award, and provided that the arbitral tribunal considers the request justified and is able to determine the claim without reopening the proceedings. We envisage that such a clarification and substantiation of the additional award provision would make the provision more appealing for the parties' consideration. With respect to the costs of the arbitration and the deposits payable, we are delighted to confirm that the AIAC has taken a policy decision not to increase any of its fees or the prescribed costs of arbitration, given the financial difficulties many businesses, individuals, and organizations have been facing in recent times. What we have done is we have corrected some computational inconsistencies to ensure a more accurate deposit calculation. By retaining similar deposit calculations to those found in the 2018 rules, the benefits outlined per the key highlights in the 2021 rules can be availed by the parties at no extra cost. Also noteworthy is that pursuant to Rule 40.5b and Schedule 2, Clause 1e of the 2021 rules, it is now permissible for the parties and the arbitral tribunal to enter into fee agreements for the interim release of fees, provided that the total fees subject to interim release does not exceed 50% of the arbitral tribunal's total fees and expenses. Now, this is a departure from the 2018 rules which expressly prohibited the interim release of fees, although in many instances the parties and the arbitral tribunal had entered into a fee agreement for the same, which was subsequently improved by the director if the fee agreement was executed within 30 days of the arbitral tribunal's appointment. We considered a cap on the interim fee release to be essential, as there were a number of instances where prior to the hearing, the parties had agreed that the arbitral tribunal was entitled to have between 50% to 70% of its fees released. However, the scheduled time of the fee release, it was not uncommon for either or both parties to object to quantum of the fee release on the basis that the arbitral tribunal had, with all due respect, not been overly active during the course of the arbitral proceedings to warrant such a high interim fee release. Now, this was particularly so where proceedings had been terminated prematurely and the arbitral tribunal had relied on an interim fee arrangement for the computation of termination costs. As such, the AIAC has taken a proactive policy decision that although arbitral tribunals should certainly be entitled to interim fee releases if agreed to by the parties, it is only fair to place a cap on the overall quantum of an interim fee release to 1. Ensure arbitrators are adequately remunerated for their actual efforts in an arbitral proceeding prior to release of the final award, and 2. To ensure that the arbitral tribunal does not become lax in drafting the final award or otherwise seeing the arbitral proceedings through to completion due to monetary considerations. There are two additional points to note about our new deposit provisions. Firstly, pursuant to Rule 41.3b, the AIAC now is authorized to treat any claims where the provisional advance deposit remains unpaid as withdrawn without prejudice, provided that the arbitral tribunal is yet to be constituted. An analogous provision can be found in the fast-track procedure in Rule 8.7F1 of the 2021 rules. However, the distinguishing point to note is that unlike a normal arbitration where the AIAC collects deposits in at least two separate tranches, one being a 30% provisional advance deposit and the second being a 70% advance preliminary deposit, under the fast-track procedure, the AIAC collects 100% of the deposits up front in the spirit of enhancing the operational efficiency of the fast-track procedure. The AIAC is also maintaining separate fee schedules for normal arbitrations and fast-track arbitrations, where a marginal cost saving can be realized where the fast-track procedure applies. The final provision I would like to cover is the revised confidentiality provision, which bolsters one of the prime cornerstones of arbitration. Rule 44.1 reinforces the confidential nature of arbitral proceedings, while Rule 44.2 provides an explanation of the scope of the obligation to cover the existence of the proceedings, the deliberations of the arbitral tribunal, the pleadings, evidence, and other materials and documents produced in the proceeding, save for those already available in the public domain. Rule 44.3 emphasizes that the confidentiality obligation applies not only to the parties and the arbitral tribunal, but it equally applies to the director, the AIAC, any tribunal secretary, as well as any witnesses or experts appointed by the arbitral tribunal. The parties are also obligated to seek a similar confidentiality undertaking from any representative they choose to engage in the arbitration, as well as any fact or expert witness or service provider they engage. The most striking feature of Rule 44 is Rule 44.6, which allows the AIAC to publish a redacted copy of an arbitral award with the consent of the parties, in either the award's entirety or in summary form. We envisage that such a provision would not only enhance transparency in the sense that published awards can be considered as a soft reference in future proceedings, but we also consider that publishing such redacted awards would provide guidance and encouragement for new and young arbitrators in drafting their initial few arbitral awards. With that, I have now come to the end of this presentation on the key features of the 2021 rules. I hope that the drafting history, as well as the overview of the provisions I have discussed today, has provided all of you with some enlightenment on the rationale behind a number of the key changes that can be found in the 2021 rules. I am positive that these changes under the 2021 rules will increase the appeal of and confidence in the AIAC, providing affordable and invaluable case management services in both domestic and international arbitration proceedings. Indeed, with a wider range of sophisticated and tailored provisions to govern the efficient conduct of arbitration proceedings and no changes to our fee structure. We are steadfast in delivering on our commitment in ensuring that the 2021 rules is a comparable and competitive product reflecting contemporary international standards and practices on the global stage. And we look forward to seeing this through with you. I wish you all a very fruitful and informative conference for the rest of the day. Thank you very much and stay safe.